joining us today. I'm just trying to see how many people we've got joining us. It looks like we've got around about 150 people joined so far, so that's great. So welcome to our webinar on the Code of Conduct. This is a refresher webinar. Some of you may have come to a webinar that we've run before on the Code of Conduct. So what I'm going to do today is I'm going to go through our Code of Conduct toolkit and talk through the Code of Conduct. If you haven't joined a webinar with us before, the way that we do it is we'll talk through a section and then we'll give you an opportunity to ask questions. So you can ask questions by typing in a message in the chat facility on the webinar, and what I'd like to encourage you to do is to type in, just type in questions that are relevant to the section that we're discussing, and then we'll pause at the end of that section and answer questions relating to that section. And then hopefully at the end of the webinar we'll have some time left for some general questions. So what I'm going to do is I'm going to take you to our Code of Conduct toolkit. So you can find that under For Advisors here. We can also find it here under Tools on our website. This is where all our toolkits are. You can see the last webinar that we ran is available there as well, and our Code of Conduct toolkit is here. So we're going to talk through this toolkit, and I just wanted to start by talking a little bit about the purpose of the code. And I think that it's very easy, and you might notice this as we go through today, to focus on the details of each particular clause of the code. And I guess what I wanted to start off by thinking about was the overall importance of the code. Why do we have a code, and what's it there to achieve? And I guess the way to start that is to really think about the overall purpose of licensing. So there was considered to be a need for there to be protections in place for people who are getting immigration advice, for consumers who are getting immigration advice, and a need for people who were immigration advisors to be held to account to a set of standards. And so that's, you know, the overall purpose is for consumers to have confidence in licensed advisors, for there to be trust and for there to be accountability. So the purpose is to avoid the experiences that people had in the past and sometimes continue to do when they deal with someone who's not licensed, where they get advice that isn't trustworthy, and they don't have any sorts of structures in place, like having things in writing or keeping records to actually hold the person to account. So the big picture is really important. It's not just because there's a requirement in the code that you keep a record. There's actually a purpose, and the purpose is that the consumer knows what's going on, that there is that mutual agreement, and that and I guess that overall structure prevents misunderstandings, and it prevents things going wrong. It prevents consumers from paying for things which they think they're going to get but they're not actually going to get. So I think it's really important just to think about that, the big picture. So I will start talking through the code now, and if you are looking at our toolkit, you will see here that the toolkit, the purpose of the toolkit is it's really to be of assistance and to provide some guidance. But what it's not doing is it's not creating an additional set of rules. So the requirements in the code are in the code. That's what you are bound by as a licensed advisor. And here at the authority, if you're asking for guidance on those clauses and the kind of guidance that we're talking about today, it really is really to help you understand the requirements in the code. It's not about setting another sort of another layer of rules or requirements. So we always need to come back to all you're bound by is actually what is in the code. So we're really just trying to have some discussion, I guess, around what the code means in a real context, and to encourage you to talk about it, to encourage you to think about it. And one of the things that I will suggest that you do for the course of this webinar, which is I'm sure all of you will be treating as a professional development activity, is, and you may want to just note it down on a piece of paper, or you may have a copy of the code that you are that you have with you. It's just to note as we go through and think about any particular clauses in the code that you feel you need to go back to, that you might need to do some more thinking about how you manage that in your business. So just noting through, so at the end of the webinar you might have 2 or 3 or 4 clauses in the code that you're going to go away and do some more work on, or maybe quite a simple specific thing that you might make as a change in your business. So the first thing we talk about in the toolkit is the fact that the code applies to individuals. Individuals are licensed and individuals are responsible for adhering to the code. So you as a licensed advisor are responsible for your code responsibilities. And I know that this can be challenging in situations where you're an employee of a company. And your company may have guidelines around, or may have requirements around how you invoice, or the kinds of agreements that you enter into with your clients. So it's really important that as a licensed advisor who is an employee, that you have the conversation with your employer, ideally when you commence that employment, but if you haven't, then it's really important that you do, and that you talk about the fact that you are a licensed advisor and that you have particular responsibilities under the Code of Conduct. Your employer needs to see the code and needs to understand that you individually have responsibilities to meet those obligations, and that you personally can be held to account. And that applies to giving refunds, it applies to managing client money, and all of those things that are set out in the code. So we'll start now with the section that is professional responsibilities and the very first clause in the code. So clause 1, a licensed immigration advisor must be honest, professional, diligent and respectful, and conduct themselves with due care and in a timely manner. So this is a very important clause, perhaps the most important clause in the code. It really talks about your overall conduct as a licensed advisor. And it is one that comes up frequently, I guess, in complaints. So clause 1 covers how you deal with anybody. It is not limited to your clients, but of course it is how you must deal with your clients. It covers Immigration New Zealand, the Immigration and Protection Tribunal, the Minister of Immigration, the Immigration Complaints and Disciplinary Tribunal, the Authority, the courts, any other government departments, or any other licensed or exempt advisors. It's how you must conduct yourself as a licensed advisor. And honesty is up there as number 1, and I think that it's probably fair to say that is the number 1 requirement under the code. So it's fundamental that you're honest with the people that you are dealing with, and it is taken very seriously by the Complaints Tribunal. So there are a number of decisions that refer to honesty, and for example, It goes as far as, if you are overcharging, can actually be considered to be being dishonest. So if you're charging excessively for a service, it's actually not being honest about what the true value of that service might be, and we've had a decision around that. Secondly, we've got professionalism, and that is what is expected of a licensed advisor is to be professional, to have integrity, to act in your client's best interests, to understand the limits of your knowledge and your skills and the services that you can provide, to be respectful, and to be aware of what is expected generally by the rest of the profession. And there are a number of decisions we've got listed here that give you some examples of those. So being diligent is also covered here, and I guess this is really about turning your mind to the things that need to be turned to in the work that you're doing, to make a genuine effort to do the work that you've done to a professional standard. We've also got respect in here, and I think this is it's very important that licensed advisors are being respectful to the clients that they are dealing with, and also to the organisations that they are dealing with. It's about treating people with consideration and not being offensive. And when we do see examples of people not being respectful and not being professional, it does often call into question other things in terms of being objective and really providing the best kind of advice that you could to a person in that situation. Then we have taking due care, and I guess there is an expectation that an advisor will do a good job, and we all get busy. We all have huge amounts on, but you need to take care in any given situation, and your client has an expectation that you will take due care in their situation. And when people or when advisors don't take the time to take due care in a particular case, that is when things can go wrong. And again, we've got a number of examples of decisions there. Acting in a timely manner, I think that probably goes without explanation, but acting in a timely manner is really something that is so important to clients, and if something isn't undertaken in a timely manner, that's often when a complaint might arise. So in terms of this initial first clause of the code, we also point out that negligence is a ground for complaint. And so negligence is when someone behaves, or they're not doing what a reasonable person would do in a situation where that person owes a duty of care. And there are a number of decisions around negligence, and it really is, I guess, often it is a step above a simple breach of the code, and that someone is really is being negligent in a particular situation and is not doing what they ought to be doing in that situation. So that is our first clause, and then we go on to clause 2. So clause 2 is about client care, and we do talk up front about how you define who your client is. The code doesn't do this, but we say that the client could be any individual, firm, legal entity or organisation who you are providing immigration advice or assistance to. So you need to be clear who your client is, and in any given situation, and then you may have more than one client in a given situation. So at clause 2A, it talks about maintaining a relationship of confidence and trust with the client and providing objective advice. So you're required to establish a relationship with your client, and possibly one of the things that we see going wrong in this space is when advisors don't establish a relationship with the client at all and they rely on their staff to do that, or somebody else. So it's really important up front that you think, well, actually as a licensed advisor, I need to enter into a relationship with my client and develop a relationship of confidence and trust with them. And that allows me then to provide them with objective advice. So it's important not to take this for granted and to, I guess, actively think about how you are entering into a relationship with the client. Clause 2B talks about acknowledging the cultural norms and values of the client. Now obviously as a licensed immigration advisor you're dealing with people potentially from many different cultures with different expectations of what's normal, what's acceptable behaviour. So it's important that you are able to acknowledge that and appreciate it. And there is some information here in the toolkit which I'm not going to go over now, but you might like to come back to. You may not always identify with the particular values that your clients have, but it's important that you are able to be aware of them. Thirdly, here, clause 2C, you're expected to facilitate the provision of interpreters and translators as appropriate. And so this is an expectation under the code. If you can't communicate directly with your client because of a language barrier, you are expected to use interpreters and translators, and you need to make provision for that. There's quite a bit of information about using interpreters and translators here in the toolkit, and again I'm not going to go into it in detail, but what I will say is that you need to think carefully about who you're using as interpreters and translators. They need to be trustworthy, and you need to know that they can actually communicate the advice and the communications that you wish them to as the licensed advisor. So one concern that I have seen is where a person may use, for example, someone in a recruitment company who happens to speak the language to communicate with them. They're not officially an interpreter, and there may not be that direct instruction in terms of what they are expected to be telling the client. So it's really important that you understand, I guess, the principles of interpretation, good interpretation, which are covered here in the toolkit, and ideally you would be in a situation where your interpreter is interpreting or translating exactly what you are would be telling the client otherwise in English. So there are, you need to take caution if you're not using trained interpreters, and there's quite a bit of good information here on that. Clause 2D is around where a client may be eligible for legal aid. Now these are very limited circumstances in relation to refugee status or protection claims or appeals or immigration detention. So you need to be aware of that clause if you are dealing with clients who may fall into that, and you simply need to advise them that there's a potential they may be eligible for legal aid. And if you are not familiar with this clause, I do encourage you to refresh by going back to this part of the toolkit. Clause 2E, this is a really important clause, and I guess it's along the lines of what I talked about with clause 2A, maintaining that relationship of confidence and trust. You have to enter into a relationship with your client, and then you have to obtain and carry out their informed instructions. So I will just focus on that a little bit firstly. It's very important that you as the licensed advisor obtain the instructions of your client. So you are required to do that, and you should be keeping a record of that. The instructions have to be lawful, so if the client is instructing you to do something that is not lawful, then you obviously are not in a position to take on those instructions. But where we see things going wrong mostly is advisors failing to get instructions. And now that may either be at the very beginning of the relationship where they again are relying on staff or other agents to do that for them, or it may be further down the track in the relationship where the advisor may make an assumption about the next steps to take out. For example, if a visa application is declined, what they do next, you need to get the instructions of the client, and you need to keep that recorded in writing. And then the advisor is responsible for carrying out those instructions. So that comes down to doing what you've committed to doing. And again, we've got a number of decisions there that you may wish to go back to and read. And then clause 2F talks about when requested, assisting the client to access information about the Treaty of Waitangi and tikanga. So that it's important to be aware of and to recognise the cultural context and history of New Zealand, and to be able to provide information on that where it is something that your client is interested in and is seeking your assistance to. And we've got some information on our website that you can use to assist you in with that if you wish. So I've been talking for a little while now, and what I'm going to do is pause because there are some really important clauses in clause 2, particularly A and E, and I'd just like to hear if there are any questions on clause 2 or clause 1 before we move on. Sorry, I forgot to say at the beginning of the webinar, I've got Catherine Rosie, who's our Senior Technical Advisor, helping me out with this webinar today. And so she will read out any questions that have come in so far on clause 1 or clause 2 or anything that I've covered so far in the webinar.
Okay, we have a couple of questions here. We have a couple on what you were initially saying regarding the responsibility of the advisor. So one of these is, will the authority consider to publish relevant regulation to regulate, restrain, or even constrain employers of the licensed immigration advisors? And I think that leads into the second question here, which is, it would be unfair to have licensed advisors take unlimited responsibility as employees. As employees, there is always pressures imposed by employers. If those employers are totally waived from taking any responsibility, they may not respect the licensed advisor's resistance when it comes to certain conflict of interest between employers and employees.
Look, I realise this is challenging. And I appreciate how difficult and challenging it may be in some situations for employees. The way that the system has been set up is that the responsibility does fall on the licensed advisor to follow the code. Now, of course, any situation will be looked at on the specific circumstances in that situation. And if we can see that the licensed advisor has taken all steps that they could to ensure that they had complied with the code, then that's obviously going to be taken into account. And it may be that there are ways that the employer can be held to account. They may have actually done something unlawful as well, and there are other avenues for pursuing that. But in terms of your responsibilities as a licensed advisor, they do sit with you, and you do need to ensure that the working situation that you are in allows you to follow the code. So you do need to take steps to make sure that you can do that, and if you can't, then you do need to consider your situation. So there have been tribunal decisions where there's clearly been a breach of the code, so for example around refunds. Refunds haven't been provided where the work hasn't been done or the work has been done unlawfully, and the tribunal has required the licensed advisor to pay the refund even though the money would have gone to the company, they were being paid a salary. So you do need to be aware of it, and you do need to think about your situation and how it's working.
Okay, and we have a question here regarding using interpreters. Someone wants to know how they can keep a record if we use interpreters.
So if you're using a professional interpreter, and let's assume it's face-to-face, or even if it is you know, over the phone, your record, I mean, you need to have guidelines in place so that you are, the expectation is that the interpreter is interpreting exactly what you are telling the client, and that's the kind of service you'll get with a professional interpreter. And so what you have said is you know, you can keep a record of what you have said, and what you've said to the client, and what they have said back to you as conveyed through the interpreter, so that you should be able to keep that record in the same way as had there not been an interpreter involved, and you can put that to them in writing, and if that needs to be translated, then they should be you know, confirming that it's an accurate record through that translation. So it should work in the same way, and that's why I guess you need to have confidence that the interpreter is acting professionally and that they are conveying what you have said, and they're not just kind of adding their own sort of comments and thoughts and things, and likewise that they are conveying back to you what the client has actually said. It is more challenging, I appreciate that, and that there are some good guidelines in the toolkit on the kinds of things that you need to expect from an interpreter, and that's why it's much better to use a professional interpreter than somebody who maybe doesn't have that understanding of what's expected from interpreting, and they don't have that understanding of the need to convey exactly what's being said.
Thank you.
Any other questions?
Yeah, there's a couple more here. So some of us licensed advisors have a Facebook page with different licensed advisors with differing experience. We have two advisors who like to criticize others, and sometimes the comments can be quite harsh and bullying and bordering on racism. When this was challenged, it is often met with ridicule. Does the Code of Conduct cover such situations, or is social media not controlled by the IAA?
It doesn't matter what the media is, what the medium is. So as a licensed advisor, all licensed advisors have the obligation to be professional and respectful, and that includes in your dealings with other licensed advisors. So those Facebook forums with licensed advisors, you should be being professional and you should be being respectful. And yeah, that is, I think so many problems would be avoided, not only with clients but just generally, if you really took it on board to, you know, in your professional dealings, when you're dealing with other advisors, when you're dealing with your clients, just to always be professional and respectful. And you can always communicate things in a way that isn't angry or it isn't derogatory, and it's really important to, and it's very helpful for you as a licensed advisor to come back to those principles. And as a licensed advisor, you've got that obligation. So I'd really like to encourage all of you who are listening out there to take it on board, to really be professional and respectful to fellow licensed advisors, whether it's on Facebook or in any other context.
There was a follow-up to that question. To follow up on the question, is the IAA able to deal with this if it comes to you as a complaint?
Yeah, so we would be required to deal with it if it came to us as a complaint. And it would need to meet all the criteria for a complaint. It can't be anonymous, has to be in writing, and it needs to disclose grounds for complaint, which includes breach of the code. So if it meets those basic requirements, then we'll look into it.
Okay, sorry, we have a couple more coming through. I have a client who used an agency overseas that has a licensed advisor as a consultant to the business indicated on their website, but the company was providing the advice from unlicensed staff. How does the code ensure that there is accountability for the clients of the company where the licensed advisor is associated with the company, but the clients of the company are not under the licensed advisor as clients?
So, I mean, that's the kind of thing that can come to us as a complaint, and we have been getting a number of these, and I think I've said this in various other forums. We, unfortunately, there are, it seems to be a recurring theme that we have unlicensed staff. There may be a licensed advisor associated with the company, but it's the unlicensed staff that are dealing with the client. So we had a whole webinar on that recently. I'm not going to go into too much detail with it now, but potentially it could come through as a complaint against the unlicensed staff and a complaint against the licensed advisor for condoning unlicensed advice within the business. And I'll actually come to that I'll come to that next. In fact, that's a nice segue. I think I'll just move on. We can possibly pick up the rest of the questions later, but if I'll go into clause 3. So clause 3 is acting in accordance with the law. So under clause 3, a licensed advisor needs to operate if in New Zealand in accordance with New Zealand law, if offshore in accordance with the law of the jurisdiction that they're operating in, and whether in New Zealand or offshore in accordance with New Zealand immigration legislation, including the Immigration Act 2009, the Immigration Advisors Licensing Act 2007, and any applicable regulations. So clause 3, this is this is one of the clauses that we deal with complaints against licensed advisors who have allowed or condoned unlicensed staff to provide immigration advice because they're not complying with the Immigration Advisors Licensing Act. So this is the main issue that we deal with under clause 3, although potentially it could be other, there could be other breaches of law that comes our way, although it's not quite so common. So as I've just said, we have done a whole other webinar on this particular topic, which you're able to view on the video on our website if you missed the webinar. And there are numerous decisions on this topic. I can just mention that this toolkit was last updated with decisions a year ago, and there have been new decisions on this topic that have come out since then as well. But even a year ago, there were numerous decisions available on this topic. So I will move on from clause 3 to clause 4, which is confidentiality. So under clause 4, a licensed advisor must preserve the confidentiality of the client. There are only limited circumstances where this doesn't apply. So the one that's probably most common is that you may get the client's written consent. So generally you're going to preserve the confidentiality of the client unless you've got the client's written consent. There is an exception if you're making a complaint to the authority, and if the client really doesn't want you to, but you feel such an obligation to do so because it's a compelling case, for example, then you are actually able to do that without the client's consent. And yeah, 2 and 3 are very similar there for the purpose of the administration of the licensed Immigration Advisors Licensing Act, and if there was any other requirement for you by law to disclose that information. So it is really important that you take this seriously and that I guess confidentiality is your default position, that you are always preserving that confidentiality. It is the heart of a relationship of trust, and as I mentioned before, you need to be able to have a relationship of trust and confidence with your client. And yeah, it provides that safety that the client can feel to tell you the information that they need to for you to do your job. Clause 4B requires that you require any employees or other people engaged by the advisor to preserve the confidentiality of the client. Now, it's worded in this way because we appreciate that you can't always ensure that they do keep the confidentiality, but you can establish a requirement. So that means that you've got in writing up front that they will preserve the confidentiality of any client information that they are privy to, and that you've done your best to ensure that they do. We do appreciate that you may take those steps and then there still may be a confidentiality breach by the employee or another person, but if you can show that you've taken all possible steps to require them to preserve the confidentiality, then that does provide a protection for you. So that is clause 4, which is around confidentiality. And we don't see too many issues with this, with confidentiality, although it does come up from time to time where, for example, the advisor might publish a story in their newsletter or on their website or something that breaches confidentiality, and that kind of thing is taken very seriously if it does occur. So the next clause is around conflicts of interest. So there's a three-step process here. So conflicts of interest, I guess the principles behind conflict of interest is that there is this concept of good faith and that you have undivided loyalty to your client. So you have this duty to act in their best interests, and you're free from any competing and other interests to anyone else, including yourself. So a conflict of interest arises when your own interests or the interests of another client of yours may influence your judgment or actions towards a client. So it can arise between you and your client, or potentially between two clients. So acting in one client's best interests may not be in the best interests of another client, in which case you may not be able to act for both of those clients. So under clause 5, where a licensed advisor is aware that there is a potential or actual conflict of interest relating to the client, including existence of any financial or non-financial benefit the advisor will receive as a result of the relationship with the client, the advisor must disclose the potential or actual conflict to the client in writing. So this is the first step, is transparency. The client needs to be aware that there may be some potential conflict of interest. So the advisor should explain it to the client as fully as possible and in writing. So clause 5 talks about financial or non-financial benefit, and so this needs to be disclosed, and you just need to think about what needs to be disclosed and with the idea of being as transparent as possible in the circumstances. So financial, non-financial benefit, some examples of things that might come up would be commissions from schools. That's a common one, I guess. Commissions potentially from any other organisation that you might be providing services or advice on to the client. Potentially around employment. So if you've got any interests in that, but in the client being employed in that particular job, particularly if you are the employer, that's really sort of alarm bells are going off there. So those are just some examples. I'm sure that you've got others. So clause 6, where a licensed advisor is aware that there is a potential or actual conflict of interest relating to the client, the advisor may only represent or continue to represent the client where the client gives written consent. So the first step is to disclose it fully in writing. The second step is to get the advisor's consent to go ahead. So this is a really important step, and if any issues arose with conflicts of interest, that you weren't giving objective advice because you had an interest in something, then it's really important that you've got it documented, that A, you disclosed it, and B, they consented to you going ahead. And that's why it's really important that the disclosure is full, so that they are actually giving consent to with full information. And then clause 7, I guess, is a little less black and white, and this really requires you to think about the circumstances. So under clause 7, a licensed advisor must not in any circumstances represent or continue to represent the client where they are aware that there is an actual conflict of interest. That means the advisor's objectivity or the relationship of confidence and trust between the advisor and the client would be compromised, or the advisor would breach the confidentiality of a client. So you need to consider this. If you would breach the confidentiality of a client, then you can't act for them. You can't act in this situation. I mean, maybe another client's confidentiality you're breaching. And can you maintain a relationship of confidence and trust with the client in light of the conflict of interest? And I think a real one to consider here is that case of you're wishing to employ the client. Can you actually be the advisor and the potential employer in this circumstance? So where in doubt, I think it's prudent for you to consider, actually it's best that I don't represent this client, and that makes it straightforward. However, that's a decision for you to make, and depending on how significant you think the conflict is, and also the willingness of the client to give their consent. But I think it is important that you are aware that in some situations a conflict of interest may mean that you can't represent that particular client, and that's okay. So that's the conflict of interest clause. I'll move on a little bit further before we stop for questions again. So you need to work within the limits of your knowledge and skills. So it's very important that the client can rely on you as an advisor to have the knowledge and skills and the particular area that they need your assistance with. So under clause 8, you need to work within the scope of your individual knowledge and skills. or under the direct supervision if you're a provisional license holder, or you refer the client to another professional. And I know many advisors say, look, I don't work in business, for example, I don't work in the refugee area, and I'll always refer those cases on. If you're a limited license holder, you need to explain that to your client, and you're obviously limited to advice in those areas. And if you're a provisional license holder, again, you need to explain that to your client, and that you are required to work under direct supervision, and that you need to seek advice from your supervisor whenever necessary. So it is important that you do think about a particular your particular case, and particularly if it's an area that you don't work in or that you haven't worked in, you need to consider whether, in fact, this is within the scope of your knowledge and skills. And it really isn't fair to the client to take them on if you're not competent in that particular area. Clause 9 talks about futile immigration matters. So it's really important, firstly, it's important to think about the prospects of success, and I'm sure that you're all doing this when you're considering taking on a client. But you really need to think about the prospects of success when you're taking on a client and when you're entering into that relationship. You need to stop and think, and you need to consider whether this application is, has little or no hope of success, or is futile or grossly unfounded. And in those cases, you have to advise your client in writing that, in your opinion, it's futile, grossly unfounded, or has little or no hope of success. And you also have to get your client's written consent to go ahead if they wish to, after you've advised that to them in writing. So, this is something that we look at, particularly if we're inspecting advisors and we see that they have a lot of similar declines. We would be looking at this, and we would be questioning whether they had provided that advice to their client, and whether they had that written consent in place. We do note that it may be simply easier to include this in the written agreement. That's a possibility, but you certainly need to have it in writing. And then the last section under professional responsibilities is clause 10, and it talks about professional relationships and some specific responsibilities that advisors have in dealing with other stakeholders. So this includes other advisors, Immigration New Zealand, the IPT and the authority. So it's important to remember that clause 1 applies, as we've talked about already, to your relationships with all of these people. So these are additional, more specific requirements. So 10A talks about where clients have used another advisor. They need to ensure that the previous contract has ended, or that the client has terminated the services in writing, or with the client's written consent terminate the services in writing on the client's behalf, or if the client wishes to continue to engage two people at once, that there are clear instructions on the terms of engagement with each advisor. So that's something to be aware of if you know that you're taking over a client who has previously dealt with another licensed or exempt advisor. So under clause 10B and C, you need to comply with the operating requirements of Immigration New Zealand and the IPT. So I think that's fairly self-explanatory. INZ and the IPT have their requirements, their instructions, and it's important that as a licensed advisor you are complying with those. And we've got a little bit of additional information here for you. We've also got some tips around communicating with Immigration New Zealand that you might like to come back to, and also some of the requirements that advisors should be aware of when dealing with the IPT. Just also a reminder, particularly around the IPT, that you need to work within the limits of your knowledge and skill. And we do have concerns raised with us by the IPT from time to time that advisors are representing clients at appeal where they don't have the experience or the understanding of what's expected in that process. So it's really important if you are dealing with the IPT that you do what you need to, and whether it's training or mentoring or study of some kind to get yourself up to speed with the knowledge and skills that you need in that area. In regard to the Immigration Advisors Authority, you need to disclose to us in writing any information that would have a material effect on your licence. That includes, just as a reminder, any conviction that you might have, even if you may consider it to be minor or unrelated. And of course, detail, you need to tell us about your change of details as recorded on the register within 10 working days after the change. So that includes addresses, and that's just a reminder there that you need to do that. It's also important to update us on your secondary business addresses. This is a reminder that you need to keep those current and up to date. So that takes us to the end of the professional responsibilities section of the code. So I will just pause there again and see if we've got any particular questions. Catherine, if you can just, if there are broader questions, we'll leave those ones to the end, but if we can just take questions on this particular section of the code, that would be great.
Okay. So we have one here, conflict of interest. Sometimes there might be a situation to work for the licensed advisor's own family member. How would you manage such a situation?
So there's clearly a conflict of interest there. So you absolutely have to go through clauses 5 and 6 and have it set out in writing and have their agreement to go ahead. But you need to stop and consider you know, whether really you are the best person to provide advice to a family member, or is that conflict so significant that really it's better that they get professional advice from somebody else. Now that may potentially depend on the relationship that you have with that particular family member, but I would seriously consider whether you're the best person to do that or not. You are a professional licensed advisor when you hold a license, and most of your clients of course are not going to be family members, and it may simply it may simply be better from a professional point of view, potentially also from a personal point of view. You need to consider what might happen if things don't go the way that they wish. So yeah, I would enter into those kinds of relationships with a great deal of caution.
Okay.
The other thing I'll comment, sorry, I'll just comment on one other thing on that, is if you are dealing with family members or people, you still have to follow all of your obligations under the code. You have to have a written agreement. You have to document your material conversations. And if you actually think that you couldn't do that because they're a family member and you couldn't act in that professional way with your family member because of the particular relationship you have, then you can't act for them. You have to be professional. So if the nature of the relationship, and that goes to any relationship, means that you would feel awkward or incapable of following your professional responsibilities, then you can't act for that person.
Okay, question regarding confidentiality. I'm thinking of writing a blog about immigration. Can I take some examples from client situations without mentioning their name or other private information?
So you can, but you need to take great care that you are not inadvertently disclosing the details. So, you know, there may be something unique about their situation, and I think you need to put yourself in the position of, if I was reading this and I was, is there anyone reading this? Maybe it's there, you know, is there anyone reading this who could potentially identify that person? So you really do need to make it very anonymous, and maybe it's better to change some details so that it's actually a slightly, you know, sort of maybe a combination of clients or something like that. But you really need to make sure that it's that the person isn't identifiable, and so often it will be more than just not naming them. And you also need to think about how unique or common those circumstances are. If the circumstances are very common, then it's not going to be attributable to any one client. But if you've had one particular client that was very interesting but very unique, then, you know, maybe that client would be identifiable to someone else. So it'd be better not to.
Okay, another one here. In particular cases where legal aid is not available and no lawyers or immigration advisors would consider representing an asylum seeker client, for instance, the client still requires representation. Is it recommendable for an immigration advisor to undertake a case like this with some support, mentoring from lawyers or colleagues?
So that's a decision that you have to make yourself, depending on the situation and your level of knowledge and experience. So if you feel that you can't take that on because you don't have the knowledge or experience, then you can't take it on. Just because they don't have somebody else is not necessarily a reason to take it on. So you need to go back to, you do have a requirement to work within the scope of your knowledge and skills. So you do have that requirement. So you need to, you know, you need to identify whether you can provide that service or not. And if you can't, then you can't. So you may need to upskill yourself in whatever other ways before you can take that client on.
Another question regarding conflict of interest. What if the advisor is also a professional translator and translates documents for the client? Would that be a conflict of interest?
Yeah, potentially. Yeah, I'm not quite sure off the top of my head. So, you know, you need to think about it in the circumstances, and if you think that you know, it may depend on what's being charged and that sort of thing. I mean, if you're charging for those services, potentially there's a conflict of interest there. If in doubt, simply record it fully in writing to your client and have them agree to get this consent for you to conduct those services as well.
Another one regarding conflict of interest. If one advisor in a company is the advisor for a visa applicant and another advisor in the same company is the advisor for the applicant's employer, would this cause any potential conflict of interest situation?
So, sorry, can you just repeat that? So,
sorry, if one advisor is the advisor for an applicant and then another advisor in the same company is the advisor for the employer of that client, would that be a conflict of interest?
I mean, I guess, again, it may depend on the circumstances and how separately you are operating and how involved you may be in each other's work, or whether you assist or do take part in part of the process or take over if the other advisor is away, for example. So it may depend on some of those things, and again, my suggestion would be, if you if in doubt, put it in writing and make sure that it's very clear and that the client's aware of the situation. And I guess this is potentially a good example, actually, of where clause 7 might kick in. So if you've got a situation where you need to disclose a conflict of interest to your client, but that would breach the confidentiality of another client, then you're not going to be able to act in that situation. That's a clear situation where you can't act if, and I'm not saying that this would happen in this situation, but if by you disclosing that the employer or the client was a client of your colleague, was breaching confidentiality of that client, then you can't act in that situation. So that potentially could be an example of clause 7b, and yeah, so that is something that you would need to consider. Okay, I'll move on so that we make sure that we get through the full code. So the next section is on supervision, and I'm not going to go into this in too much detail because we have had a whole webinar on supervision, and that webinar is available on our website if you wish to view it, and if people are interested in another webinar on supervision, please send us that feedback and we can do it. But just very briefly, a provisional license holder and their supervisor must have a supervision agreement in place that's approved by the registrar. So that will always occur when you get granted a provisional license, and that needs to include the requirements that we've got set out here and in the supervision toolkit. There are a number of responsibilities that a supervisor must maintain. They have to hold their full license. They have to ensure that any fees charged are fair and reasonable in the circumstances. They have to act in accordance with the supervision agreement, so make sure that you're not just signing that off and forgetting what's in it. Make sure that as a supervisor you are actually following what you've agreed to do in the supervision agreement. You have to preserve the confidentiality of the provisional license holder's clients. And if there is a close personal relationship between the provisional license holder and the supervisor, make sure that this doesn't compromise the supervision agreement and that it is a professional arrangement. And you also need to inform us if the supervision agreement is going to be terminated. So there is a little bit more information in the toolkit on this here. And then the provisional license holder has to act in accordance with the supervision agreement. So it's important that as a provisional license holder you are I guess referring back to that and making sure that you're complying with that. Again, you have to give notice if the agreement is going to come to an end. It's important that as a provisional license holder you do not give any immigration advice if there's a period where you don't have a supervisor in place. So if a supervision agreement has come to an end and you're looking for another supervisor, or you're waiting for the authority's approval of the new supervisor, you cannot give immigration advice in that period. And you have to submit a new supervision agreement to us for approval. So I will just move right on to professional practice, which is the next very important part of the code. And this code is written in a way which as best as it could attempted to sort of follow through, I guess, the client engagement process that you go through with a client. And what I guess is important to remember here is that you are responsible as the licensed advisor for making sure that you complete all of these steps. So up front, a licensed advisor is expected to provide evidence of being licensed to the client. So this could be through having your license certificate on your wall if they're visiting you in person, showing them your wallet card, or providing them a link to the register. So the intention behind this is that the client can actually see that you are licensed. And that's important. It's important sort of in terms of the overall, creating awareness of the licensing regime and the expectation that advisors are licensed, and we are wanting to create greater consumer awareness that they can expect to be given that evidence of being licensed, so that if they are dealing with someone who's not licensed, alarm bells will go off for them. So that's really about the overall purpose of the regime and avoiding people dealing with unlicensed advisors. So you're required to develop and maintain an internal complaints procedure. It needs to note that the client may also complain to the Immigration Advisors Authority, but unlike the previous code, it doesn't require you to go into a whole lot of detail about the authority's complaints process. And you need to follow your internal complaints procedure if your client complains to you. So we've got some sort of expectations of what you might include in that, details of who the complaint can be made to, how they can complain, timeframes that they can expect, the kinds of steps that you as the advisor will take. Those are the kinds of things we expect to see. And I'd encourage you to come back to this section and have a good look at it in your own time. But it is really important to think about how you're dealing with complaints that come your way and what you can do to stop them going further. And I know that many advisors do this well, but how you deal with those initial sort of niggles or complaints that come your way will have potentially a real impact on whether it escalates or whether it comes to the authority or not. And we would much prefer you to be able to deal with issues yourselves and resolve them yourselves without it coming to the authority as a complaint. And we do have an example internal complaints procedure here that you may wish to draw on. So we do encourage you to take complaints seriously and do your best to resolve them without them coming to the authority. So clause 16 is around initial consultations. So sometimes people charge for initial consultations and sometimes they don't. If you're charging for an initial consultation, you simply need to have agreement to the fee for that in writing. That can be done through email, but you need to have that before you undertake the initial consultation. So that's not a full-blown written agreement. We understand that you need to have the initial consultation before you enter into a written agreement. Some advisors, as I've said, don't charge for that initial consultation and then all the fee is wrapped up when they enter into a written agreement. But if you are charging for that initial consultation, you need to have agreement to that fee in advance. So you do need to you do need to meet the requirements for those initial consultations at clause 17 and 18, which I'll come to shortly. Sorry, you don't need to meet the requirements at 17 and 18. So that means that you're not having to give them all the code and complaint documents, or follow the process of entering into a written agreement before an initial consultation. But you do need to follow all of your other obligations under the code. So that means being honest and professional and diligent and taking due care and all of those other things that we expect of licensed advisors. So that's the initial consultation, and then before you're entering into a written agreement, you need to provide the client with a summary of licensed immigration advisors' professional responsibilities as published by the authority, and we have these here available. You can see on the right hand side, and they're available in our tools section as well. So we've currently got them in English, Chinese, Simplified and Traditional, Korean, Samoan and Tongan. You need to provide this one-pager to them, and you need to explain it. So it is a very simple one-page summary of the expectations that they can have of a professional advisor, and you need to tell them that you have an internal complaints procedure and give them a copy of it. So these are the things that you need to do before entering into the written agreement with the client. And it's really important, I guess, what I will just stress here is that you do take responsibility for this as a licensed advisor. So in complaints, where things go wrong, we often see that this step has been missed. Now it won't be the substance of the complaint. We never get a complaint that was solely on the basis that they hadn't been provided with a summary of the licensed advisor's professional responsibilities. I don't recall that we've ever had a single complaint only on those grounds. But when we get more complex complaints that have other things going on, what we see is that this step has been missed. So that indicates that if advisors themselves aren't taking those initial steps and aren't taking due care in these initial steps, then things will go wrong later on. So clause 18 is about entering into a written agreement. So if you've agreed to go ahead, you obviously are providing the client with a written agreement that they need to accept. So before they accept that written agreement, you have to take responsibility for explaining the significant matters in that written agreement to your client. And then everyone who's a party to that written agreement needs to sign it or confirm in writing that they accept it. So it can be done via email. We appreciate that you don't always meet with your clients in person, and all of these steps may be conducted in some kind of electronic means. So it's really important that you do have a written agreement, you do explain it, and you do get written confirmation that everyone agrees to it. And if any aspect of that written agreement changes, you need to get agreement in writing, and again this can be done by email, but needs to be in writing, that any changes are agreed or are recorded and agreed and accepted in writing. So again, in some of the more serious complaints, these things or some of these things may have been missed, particularly this changes to the written agreement or explaining it. And then from time to time we still see issues with people not having a written agreement. So it's really important, this is a really basic important step that you need to make sure happens. And I think what we say here, that it's fair to say that confusion over what's being delivered and how much it's costing are the most common things that people complain about. So it's really important to be clear, and having a clear written agreement and agreeing to that up front is really incredibly helpful in terms of a good relationship going forward. So there, we do have some guidance here around where there may be multiple clients and how you need to, or how you may manage that. Ultimately, it will be on a case-by-case basis in terms of how you deal with the multiple clients. So, for example, you might have a primary agreement with an employer and they may be the one paying the costs, so that will cover all of the cost agreements. But you still need to have separate agreement with each migrant that, for example, at a minimum allows you, gives you the authorisation to act for that particular individual. So I will move on to the content of written agreements, which is set out in clause 19A. Sorry, 19. So I'll go through this relatively quickly. You need to have the name and license number of any advisor who may provide immigration advice to the client. So it may be just one, maybe more common situation, but if you are working with colleagues who may take over from time to time if you're away, make sure that is noted in the written agreement. You need to have authority to act from the client. If you're a provisional license holder, there are specific things there that you need to make sure are in the written agreement. 19D, if you hold a limited license, you need to specifically record those limitations. Full description of the services to be provided by the advisor, which must be tailored to the individual client. So it's really important that you are explaining to the client what it is, what is the service that you're going to provide. Immigration services, that doesn't say enough. You need to be quite specific about what services that you are going to do, so that there isn't a misunderstanding between you and the client. You need to set out the fees that will be charged. So we say here that it can be either the hourly rate and an estimate of the time it will take, or the fixed fee. So you're either doing an hourly rate and an estimate of the time, or a fixed fee for the services. You also need to note any New Zealand GST or overseas tax or levy that will be charged. Disbursements. So you need to note the likely disbursements, including the amount, if known, or a reasonable estimate. We appreciate that disbursement costs may change, in which case you would need to confirm that in writing at the point that they change, but that doesn't stop you from indicating in the initial written agreement what the likely disbursements will be, what they are at the present point in time. Where disbursements will be incurred, whether the disbursements will be paid directly by the client or by the advisor on the client's behalf. (19I), you need to ensure that your written agreement contains the payment terms and conditions for any fees and or disbursements. So this means, are you requiring money to be paid in advance? Do you have payment milestones? What are those payment milestones? Are they lodgement? Are they approval? What are those payment milestones? And or is it all going to be paid at the end? So this is where you need to be very clear on your expectations on what are the terms and conditions around paying fees or disbursements. Any fees that will be charged on unpaid accounts needs to be in the written agreement. And you also need to have a refund policy if you're taking money at all. We do have an example here of a refund policy. It's not okay not to say there'll be no refunds given, because you've got an obligation, which we haven't quite come to yet, to provide fair and reasonable refunds. So our example of a refund policy is that refunds will be assessed on the basis of what is fair and reasonable in the circumstances, and when the refund is due, it'll be paid within 20 working days of the termination or completion of services. So that's just an example. You don't have to do that, but you do have to have a refund policy in your written agreement if you are taking money of any sort. So this next clause relates back to conflicts of interest, and you need to record your conflict of interest in the written agreement. So that's the requirement to have it in writing, and their agreement to the written agreement serves as their agreement to, I guess, consent to given this conflict of interest. And then you also need to record that you have provided the summary of the licensed advisor's professional responsibilities, and record that you've provided them the internal complaints procedure. And then they're agreeing to the written agreement, and you've got confirmation there in writing that they have received those. So those are all the things to be included in your written agreement. And just going back to the question of whether you have, if you have a written agreement with more than one client, for example, an employer and the actual visa applicant. So what you need to do is, you've got this obligation under clause 19 to have all of these things covered. So some of them will be generic, like if you hold a provisional license, you would want that in your agreement with both the employer and the visa applicant. But if you're only the employer is paying for the fees, then all of these things relating to fees, and a lot of what's in 19 does relate to fees, that would only be in the agreement with the employer. But the authority to act, as I've mentioned, would be in the agreement with the client. And then you've got all of your clauses covered, all of your requirements under 19 covered off. So just in the interest of time, I'm going to continue to move on. So the next section 20 talks about fees, fair and reasonable fees. A licensed advisor must ensure that any fees charged are fair and reasonable in the circumstances. So you need to be able to justify the fees that you've charged. We've got some tips, or we've got some influences here on what might influence a higher or lower fee, such as your experience or qualification, the level of service that you're providing. There isn't a right or wrong answer as to whether you're charging a fixed fee or an hourly rate, and there is some really great information at business.gov.nz, which I think I mentioned in the last newsletter. They've actually got a calculator now that you can use for calculating your costs. And these tips here are probably quite high level and basic in terms of working out a budget, identifying the kinds of costs that you have to cover in your business, so your labour costs, your overheads, rent, insurance, all of that kind of thing. You need to work out all of these things, and I really would suggest that if you're new or if you feel like you're not doing this particularly well or could do with some help, to go to that business.govt.nz and have a go at using their calculator. And if you've got that and you've got that documented, that you've actually worked out what your budget is and what your costs are and what you need to charge, then you've got a justification for the fees that you're charging. You need to work in a manner that does not unnecessarily increase fees. So it's not okay to charge extra because you've got poor time management and it takes you a long time to do something, or because you need to rework because you keep making mistakes. That's not a reason to charge more. In fact, it might be a reason to charge less. You need to inform the client of any additional fees or changes to previously agreed fees and ensure that these are recorded and agreed to in writing. So there may be circumstances that arise that in order to do an additional service, or there may be some reason for fees changing. So if you're going to do that, you need to do it in writing and get their agreement. And as I've mentioned already, disagreements around fees are often a cause for complaint, largely because they think the advisor hasn't done what they thought they were going to do for the money. So clause 21 talks about disbursements. So you're required to charge disbursements at the actual amount, if that's known, or at a reasonable estimate of what it costs the advisor to provide the service. So in some cases, it may not be good use of your time to calculate actual disbursements, in which case a reasonable estimate may be the appropriate way to go. But generally, if you can charge the actual cost, then that's definitely the preferred way to go. You need to work in a manner that doesn't unnecessarily increase disbursements, and of course inform the client of any additional disbursements or changes to previously agreed ones to ensure they are ordered and agreed to in writing. So we've got some guidance here on calculating and processing disbursements, and so these include the different ways that disbursements might get paid and how you might manage that. So feel free to come back to this if you think this is something you'd like to review. And we have an example of an invoice for a disbursement in our toolkit there. So invoices, you are required to provide an invoice every time a fee or disbursement is payable. The invoice needs to contain a full description of the services that fee relates to. So this is where I guess it links back to the terms and conditions in your written agreement, that your invoice needs to relate to those payment milestones that you've agreed, and the description of the services in your invoice should match with the services that you had agreed in your written agreement were going to be covered in that particular fee payment. So I won't go into this in any more detail, but you're welcome to come back to it. You're only required to provide a receipt if the payment is in cash, on the basis that other payments have a transaction record attached to them, if it's electronic, for example. Refunds, so you are required to ensure that refunds given are fair and reasonable in the circumstances, and that your refund obligations can be met. You're required to promptly provide any refunds payable on completing or ceasing a contract for services. So it is really important that you think about this, and you think about this in circumstances where the client is asking for a refund, or you think that you haven't delivered the service that you were intending to do. And again, this is something that, as you can imagine, often comes up as an issue in complaints. And there are a number of decisions that you might like to go back to and have a look at. A general observation would be, if the service is not delivered, the service that you intended to deliver isn't delivered, that's probably a good case for a refund. And the other situation is that if the services weren't delivered by you, but perhaps an unlicensed staff member unlawfully, then that would also be a good case for a refund. Those are some of the things that have come out in recent decisions. Client funds. So it's really important that you understand these obligations around client funds. So client funds are not your money, they're the client's money. So that is money that you receive or that you take before you deliver the service for which that that payment is for. So you are required to have a separate client account if you are taking money in advance of delivering that service. There's quite a bit of useful information in the toolkit, which I'm not going to have time to go through today, but it's important that you recognise that this money is the money of the client, and it remains the money of the client until you've invoiced for that service, for that milestone, until that work's been undertaken. So one thing I'll just comment on is that, you know, some people come to me and they say, look, people don't pay me. How do I chase up on money that's not paid? And the answer to that is that you can establish a client account and take the money in advance. So having a client account may be in your favour, it may be in your interests. It may allow you to take that money up front and have that reassurance that once you've done the work, you're going to get paid. But doing that, you have some obligations that you need to meet. You need to recognise that the money actually isn't yours yet. You have to do the services first. So 25B, you have to set up that separate account for receiving and holding money in advance. This is just around if you do receive mixed money, put it all into the client account at the front and then take out the portion that is owed to you already. You need to make sure that you're covering any administrative costs of maintaining the account, any fees. You only can withdraw money once it is due to you and you have invoiced for it. You can only use client funds for the purpose for which they were paid to the advisor. So some of you may be aware, if you've been through an inspection, that we do look at your client fund account. We do look at the ledger for the last 3 months, and from time to time we do see withdrawals at the petrol station or the supermarket or something like that. That is not okay. You need to use client funds only for the purpose for which they were paid to you, and they can only be taken out once they are due to you. We do have an ability in there to audit accounts if we think that might be necessary, and there are a number of decisions relating to client funds. File management. So this is another really important area of work, and as I've said in regard to some of the other areas, people aren't complaining because you haven't kept a written record of a conversation. That's not the reason they're complaining. They're complaining because things have gone wrong, services haven't been delivered, or expectations haven't been met. And then often when we look into those complex complaints where things have really gone wrong, we see that there aren't any records, or there aren't sufficient records. So this is really a protection for you. It's a protection for you, and it's also, it prevents complaints arising, because when you've got things recorded, and you've got things recorded in writing, and both parties can see what's recorded, then there's a common understanding, and the complaints just don't arise. So it prevents issues. If issues do arise, it helps you defend them, and often if a complaint arises and we ask for the client file and it comes back with a clear record of all of these things, often the complaint will just be closed at that point. So there's good reasons for what appear to be, I guess, administrative burdens. So you need to maintain a file which includes a full copy of the client's application to INZ, copies of all written agreements and any changes to them, copies of all written communications between the advisor, the client, and other person or organisation. So that includes your emails. It also includes any file notes that you've taken of material oral communications. You don't have to keep file notes for every single conversation, but if there is a material agreement, a decision you've made for a course of action or advice given, you need to record it. copies of all invoices and receipts relating to the client, copies of all personal documents relating to the client, and evidence of the safe return of the client's original documents. It's very helpful if you put all of these things in place. And if you're concerned that you're not keeping your records of all of these things, then flag this clause for something to come back to after the webinar. And there's more detailed explanations in here, which I won't read out because I don't have time, but please do go back to this in terms of explanations of what is meant here. You're required to confirm in writing to the client when applications have been lodged and make ongoing timely updates. So there needs to be a written record when the application has been lodged that you've told the client this. You need to think about how often you're going to update your client if potentially there are lengthy timeframes involved, and make sure that you're doing that in a regular way. You need to confirm in writing to the client the details of all material discussions with the client. This is really important, and again, not doing this in itself is not going to be a reason for a complaint, but often we see that when things go wrong, it's because this hasn't been done, and there's been a misunderstanding around a conversation, or one person says the conversation happened and the other person says the conversation just didn't happen. So it's your protection to have this in place. You need to maintain a well-managed filing system. So we don't tell you how you have to keep your files. You don't have to keep paper files, and I'm sure you've all got very different kinds of electronic filing systems. It doesn't matter how you keep it as long as it's well managed and you can retrieve it. So when we ask to see your client file, you're actually able to retrieve it and provide it to us. And you are expected to maintain your files for 7 years and make sure that those are available. And this is something for employees to consider, that you need to have an agreement with that employer, particularly if you shift employment, that you are able to access those files for inspection. 26F, you need to, when requested by the client or their new licensed or exempt advisor, release a copy of all applications lodged on behalf of the client and all correspondence relating to the client. So we would expect that includes your correspondence with the client. So that it may include emails, and it may include written agreements, because presumably that is something that has been sent to the client. So yeah, so that is that requirement. You need to ensure that you're returning personal documents to the client, firstly you need to hold them securely, and secondly you need to return them without delay and in a secure manner. So it's important that you are thinking about how you're doing that. Termination of services. So you need to make sure that it is confirmed to the client in writing, and that if you are ceasing to act with the client for any reason other than the natural completion of the agreed services, that you inform Immigration New Zealand or the tribunal as appropriate. And you need to think about, if you can't act for the client, that you need to fully update the client on the status of the immigration matter and advise them of where they could get assistance, which may be, for example, pointing them in the direction of other licensed advisors or the register. I'm conscious of time. I would have liked to have had more time for questions, so I'll quickly just go over misrepresentation, and then we can have the last 20 minutes or so for questions. So you must take care not to misrepresent yourselves, your business, your employees, the client, the immigration opportunities or risks, or New Zealand's immigration requirements. And this really comes back to honesty, and it's taken very seriously. So we've got a particular clause around former government officials not to misrepresent their qualifications or their past employment. It needs to be strictly factual, and of course you can't promote the idea that you might have special access or influence. Applications, so you've got obligations around not providing false or misleading documents to the decision maker, and of course this is also potentially a criminal offence under the Immigration Act as well. If you do become aware that false or misleading information has been provided or concealed from the decision maker, there are some steps that you need to take here, and you need to inform the client and think about possible ways that you can remedy the situation. And if this isn't possible or the client doesn't agree, then you may need to terminate your services. And finally, you've got obligations to use the trademark correctly, and I will just put in a plug for this. It is really important that you're using it correctly, that your name is there and your license number, because we do see it misused by unlicensed advisors, and we really want to protect the integrity of that. So make sure that your website has this used correctly. Okay, so that was a rapid tour of the Code of Conduct. I hope that's been somewhat helpful, or that you've got some ideas or tips to go back to some things on. And we will spend the last 18 minutes taking questions. So I'll hand over to you, Catherine.
Okay, we have a few questions here, so we'll see how many we can get through. So a question regarding clause 18 and 19. If you have the situation where you deal with an employer and the client, would it be acceptable for advisors to use the same agreement for both parties, or must the agreements be tailored specifically to the employer and specifically to the employee you represent?
So I guess it depends if there's any confidentiality, if there's anything confidential in the agreement to either party. You need to take that into account. If you're suggesting, I'm not sure if you're suggesting that you have two agreements that each of them sign and they just look the same, or if you're suggesting they both sign the same agreement. So you need to take confidentiality into account, and it just may not be appropriate to have the agreement around fees for both. You know, you may only want to disclose the fees that you're charging to the party who's paying those, but that's really something for you to consider.
Okay, a question regarding refund. If clients pay only after services are rendered and all disbursements are advanced by the licensed advisor, would a no refund policy be acceptable since no advance is paid by the client?
The thing is that sometimes situations arise that are unexpected, and you have an obligation under the code to provide fair and reasonable refunds. So you can't have a blanket no refunds policy, and it may be that unusual circumstances arise, and you would need to deal with those on a case-by-case basis. But it's most likely, or you're much more likely in that sort of situation to address those things at the point of payment, so it's less likely to arise as an issue. But I think it's important that you're clear that you do have an obligation as a licensed advisor to consider any individual circumstances that arise, and whether there may be a case for a refund.
Okay, question regarding clause 17. When we have a client abroad, is it sufficient to email the required documents, professional standards, etc., to clients and ask them to read it, come back to us with questions, etc.?
Yes, absolutely. So we don't expect you to be dealing with all of your clients face to face. So you may do it and electronically, you may do it via Skype or email, but you still need to make sure that you've covered off that responsibility.
Okay. Does the Immigration Advisors Authority provide a standard written agreement?
No, we don't. So all the requirements in a written agreement from the authority's point of view, in terms of your obligations as a licensed advisor, are set out in clause 19. So you need to go through clause 19 and make sure all of those things are covered. There will be other things you might wish to have in your written agreement, and that's one of the reasons that we at one point we were considering it, but there are other things that you would want to have in a written agreement, and we don't have any requirements around those. Those are business decisions for you. So so for that reason, we don't have a written agreement model, and you simply need, basically clause 19 is your those are the absolute minimum requirements that you need to have. So you just simply need to go through clause 19 and make sure all of those things are covered.
Okay. With regard to providing the client with a copy of their file, do we need to give the client a copy of our own cover letter we wrote and sent to Immigration New Zealand?
So if you're referring to yes, all correspondence relating to the client, yes. Yep, that would definitely fall within correspondence relating to the client if they're requesting it, yes.
Okay. Question regarding clause 16, initial consultations. May employees who work for the advisor request the client's consent to the initial consultation fee via email, or must it be done by the advisor?
Okay, so this particular question hasn't been tested. You need to take responsibility for it. If it doesn't happen, you can't blame the employee. It's your responsibility to get that. So yeah, I don't have a definite answer for that, but you need to take responsibility for it. So and you need to have that record in writing yourself, that they have got that consent. And yeah, you need to make sure that you've got that certainly before you undertake the initial consultation. Yeah. It may be sufficient for you to instruct an employee to do it and to get it on your behalf, but yeah, the difficulty is, well, what if that doesn't happen? So you need to make sure that it actually has happened and that you've got a record of that.
Okay. Does the advisor still need to deposit all the third-party fees, such as Immigration New Zealand fees, into the client trust account, or can it be deposited directly into the company's operational account since they are not service fees for the advisor?
If it's taken in advance of you paying it to Immigration New Zealand, then it needs to go into the client account. So that is, you are taking money in advance. It's not your money, so it shouldn't be going into your business account. It's the client's money, and it needs to be going into the client account. So clause 25 is quite clear that it applies to fees and disbursements. Yep.
Okay, a question regarding termination. What do we do if the client doesn't sign agreement to terminate your initial agreement with them?
Sorry, can you just repeat the question, Catherine?
Yes. What do we do if the client doesn't sign an agreement to terminate your initial agreement with them?
So I'm assuming that you're saying there that the client wants to terminate the agreement but won't put it in writing. So, I mean, the obligation under the code is under 28A is that you confirm termination to the client in writing. The termination of services for any reason is confirmed to the client in writing. So if it's quite clear that you wish to terminate the agreement, or that they do, but they haven't put it in writing, you can confirm that to the client in writing. So that's okay.
Hi, sorry, I've actually got more information regarding that question. This is where the client has entered into a written agreement with the licensed advisor. The advisor has done some work and advised the client that they don't actually meet Immigration New Zealand criteria for residence. The client then requested the return of documents, which has not been done. The client has not responded to the advisor sending withdrawal of agreement. What does the advisor do in this case?
Sorry, what I'm going to suggest that you perhaps email us that question and we can get back to you. It's a little bit, perhaps a little bit going on there. So we'll email it in and we'll get back to you in writing on that one. Unless you've got a straightforward answer, Catherine.
No, I think it would be best if we had that emailed to us.
Okay, thank you.
If you are informing clients you are licensed but you don't meet in person but communicate by emails, is having your license number and the Immigration Advisor logo enough, or should there be a link to the Immigration Advisor website?
We recommend that you put a link to the register because anyone could sign an email with your license number off the register, but putting a link there, it's got your photo, you know, or people could make up a license number. So it's better that you put a link to the register. It's a very straightforward thing to do. So that's certainly our recommendation, that you either use your wallet card, your license certificate, or the actual register.
Someone's asked, I know people have asked this question before, but where can we get some idea about what is a reasonable fee or an hourly rate? Is the Immigration Advisors Authority likely to come up with some guidelines in the future on this, the way MARA has in Australia?
So I haven't looked at what MARA's doing recently, so I'm not sure if that's a recent development or not, but the answer is no at this stage. So we did look into it in quite some depth. Well, we did do it for a little while, and then we realised that it was a very complicated thing to do, that people provided different services, and it wasn't as straightforward as saying the average cost of a visitor visa is this, a work visa is this, and a residence visa is this. So people provide different levels of services, different packages of services, and it was very difficult to identify what was, you know, what actually was standard. So there are a range of things that influence fees up and down, and we've got a list of those on our website. So no, we're not intending to provide average fees for advisors, but I do suggest that you go to that business.govt.nz website and identify what your costs are to help you from a budgeting point of view. And so, you know, you're going to have a lot higher overheads if you've got an office, you know, an office, I don't know, depending on the nature of your office and the cost of that. So, but you do need to step back and think, you know, how experienced am I? How new am I? What service am I really offering? And come up with a fee that, you know, genuinely reflects the quality of your work and and what you're offering. And it may be that, you know, as you're starting out you charge less, and as you become more experienced that you then, you know, can increase your fees over time.
Someone's asked, where on the IAA webpage can we find the past videos of past webinars?
Okay, so they, this is something we could potentially look into putting them all in one place, but at the moment they are based on the topic. So under continuing professional development, we have the CPD webinar, which is there. Under supervision, under the supervision toolkit, we have the supervision webinar. And under tools, generally we have the recent webinar that we did on the limits of immigration advice, unlicensed and clerical staff. So yeah, so that's where they are at the moment. They're under the topic, but we may look at putting them in a centralised place, perhaps under tools, so that they're all accessible. That's a good comment. Thank you. Anything else?
Yes, sorry, I'm just trying to track it down. When we are working on partner visa applications, whom are we bound to, the applicant or the sponsor?
Well, I get that's a question for you. I mean, my assumption would be that you know the applicant, that you're working for the applicant, that's your primary client. But you know that's you need to identify what is your relationship and what services are you providing for the applicant and for the sponsor, and you need to you know be clear on those in terms of your agreements. You know, I don't whether you have an agreement with a sponsor or whether you just have an agreement with the applicant. It's up to you, but you need to be clear. What is my relationship? Am I providing services to these people? And what obligations do I have to them under the code? Okay, perhaps one more question.
Okay, someone's asked, are immigration advisors eligible for legal aid, or is it only for refugee lawyers?
Yeah, so immigration advisors can't access legal aid, only lawyers can. So that's the way that the system is set up in New Zealand at the moment. So look, is there any, oh, we might have time for one more question, Catherine. Anything else?
When the client's credit card failed, the advisor pays their visa fee for the client. How should we treat this money?
So I mean, okay. Well, pop that question in writing. Sorry, that's a little bit perhaps a little bit yeah. I haven't got an answer for you off the top of my head, and that perhaps a little bit technical, but we'll we can get back to you if you put that in writing. So I think probably now is the time to just to kind of wrap up. It is quite a challenge to get through the whole code in 2 hours, and I'm sure that there are other questions that haven't been answered, but please do feel free to email us. And what I encourage you to do now in the next 5 minutes is just stop and think, reflect on this activity and think about what are some of the takeaways for you, what are the 1 or 2 or 3 things that you want to go away and do, or change or tweak, or what do you want to go back to in the toolkit to review and go over. So hopefully that way you've got a short record of some of the things that you've got out of this session, and please do feel free to send through feedback. It's very helpful for us, for me to get feedback, and yeah, thank you very much for joining us today. I think we had around 200 people for the session today. So yeah, thank you very much for joining, and all the best in your work, and please do sing out if we can be of any assistance with any questions that you have. Okay, thank you and have a great evening everyone.